Perfect. Okay, so good morning, everyone, and welcome to our small business webinar on 2023 labor law updates. My name is Hurik, and I am an economic development coordinator here with the city of Glendale. And as part of my responsibilities, I make sure that our small business community is connected with up-to-date information and resources in order to help them become successful, because your success is obviously our success as well. And I'd like to thank Don Lowell from Pasadena SBDC for partnering with us for this webinar. I'm sure we'll be doing more partnerships later during the year. But with that said, I'd like to turn it over to Xiomara Palma, CEO and founder of Solvit HR, and she's going to kick off our webinar.
Thank you so much, Lyric. Thank you for having me on today. I know Dawn is on. I'm not sure if you wanted to share a few words with the audience, Dawn, before we get started.
So I would really quickly, Xiomara, if I could share my screen. First
Absolutely.
of all, just want to say thank you to the city of Glendale for the invite. And I agree, Hurik, I believe we'll do more of these. But I have a short video to play for y'all to give you a kind of an understanding of what we do. And then I'll turn it over to Xiomara, who's got a ton of great info. Here we go.
At America's Small Business Development Center, our mission is simple: to help businesses grow and succeed. At the SBDC, we offer no-cost consulting and low-cost training to make it easier for businesses to start, grow, and recover. As a valued resource partner of the SBA, the SBDC serves small business owners throughout the U.S. by providing timely expertise and advice that business owners can use today. These services are especially helpful for small businesses impacted by COVID-19. There are 9 SBDC locations in LA and Ventura counties, and one right here in Pasadena at Pasadena City College, where we offer one-to-one consulting with experts in SBA disaster loans, strategic planning, marketing, financial analysis, and many more vital services. For no-cost help with your small business, contact the PCC SBDC at 626-585-3105, SBDC at pasadena.edu, or pccsbdc.org. We are here to help, no cost and no catch.
So we are truly here at no cost and no catch because we are funded by the SBA and by the state of California. So with that, I'm going to turn it over to Xiomara, who's one of our many advisors, and she's going to give you an update on the newest unemployment laws. Thank you.
Thank you, Dawn, for that introduction. And that actually cuts one of my slides here. And I'm glad we had that video to tell everybody a little bit about the Small Business Development Center and what a great resource we are. I'll tell you a little bit about myself as well. I'm an advisor with the SBDC. I'm also a small business owner of a consulting firm called Solvit HR. I've been doing human resources for 15 years and counting, into deep now to back away from it. I really actually enjoy human resources. I'm passionate about what I do in helping small businesses remain in compliance and help them manage their employee life cycle. So if any employers or any businesses need any assistance with human resources, employer compliance, anything in that regard, I'm a great resource. You can reach out to sbdc@pasadena.edu to schedule a free consultation with either myself or one of our other advisors. We have quite a library of everyone who has a lot of expertise in their fields. Looking at the agenda for today, I'm mainly going to cover employment laws that are going into effect this year. We'll touch on a few others that get impacted by laws that went into effect years prior. But the agenda today, we're going to talk about some wage and hour laws that are going into effect, some laws and benefits, workplace safety, and a few other miscellaneous laws that have gone into effect. A brief disclaimer about the presentation today. As many of you know, the nature of human resources and employment law is ever evolving, and the topics that we're going to cover in this webinar today are not intended to be considered any legal advice or recommendation. They are shared with everyone for informational purposes and as best practices in employing individuals here in the state of California. So let's dive right in. First up, we have pay transparency. SB 1162 that is effective as of January 1. And this law comes with several different layers that impact employers of different sizes. Some of the areas that impact employers of all sizes, even with one employee count, is that employers have to make a pay scale available to current employees upon request. This is a pay scale of their current position. It's not a pay scale of a position they are aspiring to, but rather of their current position. They're also required to maintain records of the job title and wage history for each employee throughout the duration of their employment and for an additional 3 years after a separation of employment. So this is a new record keeping requirement for all employers to keep up with. Failure to keep these records can result in a rebuttable presumption in favor of the employee. So what this means is that if an employee files a claim against an employer for not complying with this requirement, then the law is likely to side with the employee, as many of our laws are here in California. Now, the second layer of the law applies to small businesses with 15 or more employees. And this is the part that's not being well received by many employers across the board. But now employers are required to disclose the pay scale in any job advertisement for any position they are looking to fill. This pay scale includes just a range of what the base salary for that position would be, and it excludes anything additional such as bonuses, commissions, or any tangible benefits that come with the position. If an employer also engages a third party to recruit for their positions, then they also have to disclose this pay scale to the third party in order to be in compliance. And where the employee count comes into play, I know many employers are like at the 13 and 14 employee mark and are wondering if they're gonna have to comply. The minute that you have 15 employees in any pay period, that is when the law begins to apply to you as the employer. And penalties for non-compliance can range from $100 to up to $10,000. And the third layer for this law of pay transparency applies to employers with 100 or more employees. This is something that is being expanded from previous law. A few years back, we had a law that required employers with 100 or more employees to submit pay data reports to the Department of Fair Employment and Housing. Now they have renamed themselves. They're known as the California Civil Rights Department. And a lot of employers could comply with this requirement because at the federal level, they already complied and were required to submit the EEO-1 report, Equal Employment Opportunity 1 report, which satisfied the requirement from the California Civil Rights Department. Now, this law, SB 1162, that's gone into effect as of the first of this year, adds additional reporting requirements to employers with 100 or more employees Now they must include the mean and the median for each job category, broken down by race, ethnicity, and sex. So the EEO1 will no longer satisfy the requirement of the report. And in addition to that, if you have multiple locations, then a separate report is going to need to be submitted as well. We also did see an increase to the minimum wage. We are now at $15.50 per hour for all hourly employees. And that also impacts the salary for anyone that you have classified as salary exempt employee. The minimum salary that you can pay an employee now in California comes out to be $64,480. And you also must satisfy the monthly minimum requirement of $5,373.33. So employers couldn't pay, for example, $3,000 a month and then do a lump sum at the end to bring them up to the $64,000. So there are both annual and monthly requirements. And one thing to note for many employers is that in order to classify someone as an exempt employee, is they have to meet two different tests. One is that they get paid at least twice the state's minimum wage. And then two is that they have to meet a duties test. And there are only certain positions that would qualify to meet the duties test. So it's important that many of you, if you do have salary employees, note that there is a difference. And there are two different tests that have to be met. And just classifying, just because you're paying someone a salary doesn't necessarily mean that they are going to be exempt from overtime and most of the laws that protect hourly employees. So with that, also, you need to keep in mind that a lot of our local cities have ordinances that require a higher minimum wage. So if you are located within the cities we see here on the slides, or if you do business in the cities, a lot of the city ordinances require you to pay the employees their minimum wage if the employees even engage in work within their city boundaries. So it's important to keep that in mind. If you do business, for example, in the city of Los Angeles, in Pasadena, it's important for you to review the requirements of how to compensate your employees for the time they spend within the city boundaries there. Another law, and this is the most contested area of the wage and hour laws. I would say there's always a lawsuit I would say at least every other year, we see a lawsuit related to meal and rest periods. Last year, we did have a lawsuit of an employer that was rounding the meal and rest periods time. So when in their payroll system, when the employee was clocking out and clocking back in from their meal periods, if they clock back in, let's say 29 minutes after their meal period, it will round up to 30 minutes, not necessarily in compliance with California law. So now they determined that there is no rounding allowed, and that actually applies across the board in California. There is no shouldn't be any rounding allowed, or for your payroll system to do any rounding, either when employees clock in or clock out for the day, and especially now for any meal periods. So they found many violations of employee missed meals because the system was rounding the break time, that 30-minute uninterrupted break time. The other thing that we've seen come up in recent law is that whenever an employee misses a meal, they are entitled to premium pay. And this applies if they miss a meal related to something related to work. If work prevented them from taking a meal period, then a premium pay at the hourly rate, 1 hour of their hourly rate, would apply to them. Courts has determined as of last year that premium pay now needs to be calculated not at the employee's base rate, so what you would be paying them, but at the actual regular rate of pay. So there is a difference. Many people don't know the difference between paying someone a base rate and the regular rate of pay. The base rate is, for example, if you're paying someone minimum wage, $15.50, that is their base rate. Now, if you are including things such as bonuses, commissions, any additional pay, now you have to recalculate their rate, their hourly rate, including all those other compensations that you have provided the employee for the pay period. And that should give you the rate for that particular pay period. So previously, premium pay was at the base rate, but as of last year, the court determined that premium pay needs to be paid at the regular rate of pay. And now it constitutes a wage that must be reported on the wage statement as well. We also had a law that passed to provide protected bereavement time for employees, AB 1949. This applies to employers with at least 5 employees, and it grants 5 unpaid days of bereavement time after an employee has worked for at least 30 days for an employer. The family members or the relatives that would give an employee the rights to take this bereavement time would be their spouse, child, parent, sibling, grandparent, grandchild, domestic partner, and parent-in-law. And the days must be taken within 3 months of the date of death. And an employer could require documentation to verify the death, but they must maintain strict confidentiality of the information. So another record that you need to safeguard for your employment records. And an interesting thing is that the bereavement days do not have to be consecutive for an employee to be able to take them. And if you as an employer don't provide, I know many employers provide normally 3 days of paid bereavement time, but if you do not provide any paid time, or if the employee wants to take additional pay for the extra 2 days, they can tap into any available vacation, PTO, or sick time, or whatever balances they have available to cover for their absences. We also saw the expansion of family members, or eligible family members under the California Family Rights Act and under the Healthy Workplaces and Healthy Families Act, aka known as paid sick leave. This is a California paid sick leave. So now employees can take a leave of absence, not only to care for already eligible family members, but they also can give a designation of a person that they can care for. So there are 2 definitions, one under the California Family Rights Act that defines any individual related by blood or whose affiliation with the employee is the equivalent of a family relationship. And then under paid sick leave is any person identified by the employee at the time the employer requests sick days. So the employees do have to let the employers know in advance who that designated person is going to be. But just know that this significantly expands the California Family Rights Act, something that has been going on since 2021, where the law changed from applying to employers with 50 or more employees down to employers with at least 5 employees. And that year, it also expanded and included additional family members, grandparent, grandchild, sibling, and they accidentally left out parent-in-law, which they meant to include it, but we saw that change or that adjustment last year in a different law that they passed to make that adjustment to include parent-in-law. So now essentially there is a myriad of family members and now a designated person that they can take leave time to care for. Now on CalSavers, we did see an expansion as well to apply to employers with at least 1 employee. So previously the law required employers with at least 5 or more employees to register with CalSavers if those employers did not already provide a retirement savings plan to their employees. And the deadline to register was June 30th of last year. And there is a penalty for employers that do not register with CalSavers. It's a $250 per employee penalty imposed by the Franchise Tax Board, in addition to a $500 penalty per employee if you fail to register within the window that they have provided you. So now the law expands to not only include employers with at least 5 employees, but also those with at least 1 employee. Now, it excludes owners, but you must register with CalSavers. Employers have until December 31st of 2025. And essentially, all you're doing as an employer is providing or facilitating the tax deduction or the saving plans deduction and submitting that to CalSavers for each of your employees. We also did.
Xiomara,
Yeah.
May I jump in and give you a quick break? We
Yeah,
have
absolutely.
a question in the chat. How far in advance would employees need to decide on their designated person?
That's a very good question. So the law does say that the employee does need to notify the employee within a reasonable time, but if it's not, if it's like an emergency type of situation, they have to notify the employer as soon as possible. That's what the law is. It's a little vague in what it says.
Got it. Thank you.
You're welcome. All right, so paid family leave and state disability, we had some changes there as to the rate that now employees are going to be able to get benefits for wage replacement when they go on leave. So paid family leave, many of you may not be familiar, is the wage replacement program that provides employees compensation for when they take time to care for a family member. We just saw all the family members that they can care for, or for their own illness, or for their own illness through disability insurance. So currently employees get up to 70% of their compensation of their pay whenever they apply for these programs. But this law is going to change and increase the percentage that employees are going to be eligible for up to 90% of their earnings. There are grants for small businesses that will provide cover costs associated when an employee goes on leave for either cross training or hiring or advertising jobs. And it is $2,000 for employers with 1 to 50 employees and $1,000 for those with 51 to 100 employees. The eligibility that needs to be met for employers to apply for the program is that they have to employ at least one to 100 employees, be registered to do business in the state of California, be in an active status with the Office of California Secretary of State, and have an active California employer account number in which you have employees listed for payroll. There is a deadline to apply, which is May 31st of 2024, but I can tell you right now that there is a waiting list for employers to apply for the grants and be able to benefit from it. So you can check out the application process on the link submitted there. And one interesting thing to note is that if you do have a PEO, a professional employer organization that manages your payroll and your HR and workers' comp, etc., you are not eligible to qualify for the grant. Now, on the workplace safety side, we did see a few laws that went into effect. We had SB 1044, which prohibits an employer from threatening or taking adverse action against an employee for refusing to report to or leaving work if the employee has a reasonable belief that the workplace is unsafe. And it also prohibits an employer from not allowing a worker to use their mobile device or any other communication device to get emergency assistance, assess the situation's safety, or communicate with someone to verify their safety. Employees are required to notify their employer in advance, if not also as soon as possible. But the law defines emergency condition. It excludes a pandemic. A pandemic is not considered an emergency condition under the law, but it defines it as either one, conditions of disaster or extreme peril to the safety of the persons or property at the workplace caused by natural forces or a criminal act, and or two, in order to evacuate a workplace, worksite, worker's home, or school of a worker's child due to natural forces or a criminal act. So that is what we have as what the law defines as an emergency condition. And it's important to note that many employers have a policy preventing employees from using their cell phone and or other communication methods to not disrupt the operations of the workplace. That you might need to revise those policies in order to be in compliance with this new requirement here. And also important to note that some healthcare workers and disaster service workers are exempt, among others, from this law. Now, on the COVID-19 side, we saw what we have had quite a saga with the emergency temporary standard. We do have this new law also that adjusts or amends the current COVID-19 notices requirements. As many of you may recall, back in November of 2020, Governor Gavin Newsom required employers to notify employees within 1 day of a COVID-19 case in the workplace. And there was a myriad of criteria that needed to be provided in that notification as well. Now, this law amends that and says that posting the notice is sufficient, but it must be posted for at least 15 days. And it must include the dates of the infectious period when the case was on site. The other interesting thing is that employers are no longer required to report COVID-19 cases to their local health departments. And this notice extends to January 1, 2024. A lot of the COVID-19 regulations were set to expire as of December 31st, 2022. So a lot of them are getting extended right now. And here we go. We have this saga going on with the emergency temporary standard. We have had many changes since it was adopted again back in 2020. And currently, OSHA is trying to adopt a 2-year non-emergency temporary standard to replace the current emergency temporary standard that most employers are complying with right now. It's still pending approval from the Office of Administrative Law. So the emergency temporary standard was set to expire as of December 31st, and they were hoping to have this new non-emergency temporary standard in effect by January 1. However, there's been a delay due to their procedures and needing approval from the Office of Administrative Law. But some of the things that once it does go into effect, some of the expected changes you can see is that the COVID-19 prevention plan will no longer be required for employers to have. Rather, employers can comply with COVID-19 regulations, including those in their injury and illness prevention programs or plans. If you do not have an IIPP, you are required to have one, and you must also include all the procedures that you're taking that you're implementing to prevent the spread of COVID-19 there. You also, under this emergency temporary standard, employers were required to report COVID-19 cases to their local emergency department or to their local health department, sorry, and that is going away as well. And the most significant change is that they remove the requirement to provide exclusion pay to all those employees that were excluded from the workplace because they were exposed to COVID-19. Some things that did not change is that employers still have an obligation to investigate COVID-19 cases. They must include the dates of the positive test and the symptoms presented by the positive cases. And they must maintain effective policies and protocols to prevent the spread of COVID-19. Again, you want to do so now in your IIPP. You can still maintain the COVID-19 prevention plan. There's nothing that says you cannot have it, but it probably will be easier to incorporate it into the IIPP in order to be in compliance. The close contact definition also did not change this time. It's still sharing the same indoor space for facilities that are less than 400,000 cubic square feet and or 6 feet of distance for those facilities that are over 400,000 cubic square feet. This is something that actually did change back in, I believe was October, something that had been changing back and forth, but currently this is how it remains. And last, you still have to provide free testing for those close contacts that you become aware of in the workplace. A few other laws, this is more in the discrimination or anti-discrimination, I should say, area. We had AB 2188, which protects an employee or an applicant based on their use of marijuana off the job and away from the workplace. And it does clarify that the employee or the applicant may not possess or be impaired or use marijuana on the job. So that's good news. And then we had SB 523, which amends the California discrimination law that protects employees from discrimination. And it includes reproductive health decision-making under the protected categories as to why people would not be discriminated against on the job or as an applicant applying for a position. And with that, I will bring it to closure and open it up to any questions that there may be in the chat.
Thank you, Xiomara. So we do have one question from Tom. He is asking, how is an employee defined for Cal Savers? Full-time employee or simply one payment, such as a concert?
Say that the last part one more time.
No problem. So his question is, how is an employee defined for Cal Savers? Full-time employee or simply one payment, such as a concert?
So it would be, the definition would be based on California law. So whether you have someone that is part-time or full-time, so as long as you're compensating that person within the definition of the law, that would apply to you. You would have to pay them. I mean, if it's someone that's working for you, the trigger would be at least you're paying them $600. That would be the trigger for someone to actually become and be considered as an employee. But to my understanding right now, it does apply regardless of their status.
Okay, perfect. And then I have a question from Mindy. So reproductive health decision-making is pregnancy and or gender change?
Yeah, it could be. It could be. It's pretty vague as to how it's being defined, but it could be. Yeah.
Perfect. And then we have a question from Lyris. Can you please review the minimum salary for exempt salary?
Minimum salary for exempt salary. So in order to truly classify someone as exempt, and we're talking about them being exempt from overtime and the meal period requirements all the laws basically that get covered under a wage order. In order to do that, in order to exempt someone from those protections, you have to satisfy two requirements. One, they make at least twice the state's minimum wage, which we saw was $64,480 right now. And then two, you have to ensure that they meet the duties test. Their position meets the duties test in order to be eligible or to be classified as exempt from overtime and all the other laws that protect hourly or manual labor. So those are the two requirements. There are different criteria for the duties test. There are different positions, for example, like determining whether someone is a professional or a licensed professional or a salesperson. Some sales positions may qualify, or an executive may qualify. So there are quite some criteria that need to be met. If you have more questions, I encourage you to schedule a one-on-one. We can go through what some of those criteria are to see if they apply to a position that you may have as an exempt position.
Thank you. And we have another question from Ellen. Does the SBDC have other resources to share, such as mandated training for new non-emergency COVID regulations?
Don, do you want to answer that one?
Sure. So we don't have a workshop specific to non-emergency COVID, but that could be something Xiomara could help you with in a one-on-one to develop that training and make sure you're following the guidelines.
Perfect.
Thank you, Don. Yeah, I'd just like to add to that, in order to be in compliance too with a lot of these regulations, the Department of Industrial Relations has also developed a website where they have a lot of the changes that they are making to the emergency temporary standard, the status. They have frequently asked questions, and then they also have a sample COVID-19 prevention program, and they also have guidelines to develop an injury and illness prevention plan. You can find those on their website, dir.ca.gov. If not, I'd be happy to walk you through what those requirements look like, and yeah, I'd be happy to assist with that.
Thank you, Xiomara. So we do have a follow-up question from Ellen. Also regarding PFL grant application, must businesses have less than 100 employees in California or nationwide?
That's a very good question. I believe that it's, I don't want to provide wrong information. I do want to say that it's probably nationwide, but I would have to look into that. So if she wants to provide her contact information, I can get back to her on it.
Wonderful. And everyone else, feel free to ask questions or put your questions in our chat feature, and we're happy to answer. Xiomara, I have a question, and you probably touched on this, but for Senate Bill 1162, you noted that it's applicable to 15 plus employees. What constitutes an employee? Is it a full-time employee, or you mentioned something about a 600 threshold? Can you elaborate?
Yeah. So it's basically it's any employee you have on payroll. So once you whether it be a part-time employee, a temporary employee, a full-time employee, anyone that you have on payroll, and once you hit that 15 person count on your payroll system, that's when the law becomes applicable to you.
Perfect, thank you. So we have a question from Barbara. AB 1041, designated person. An employer can limit this to one person per 12-month period. This condition needs to be defined in our policy, right?
Yes. Yes. Yeah, a lot of these laws are going to require or trigger employers to update their policies to make sure that they are providing a clear definition to the employees and also prevent abuse of the policies. But yes, that's a great point.
Okay, it seems like we don't have any questions. To answer Lyris, yes, so the city of Glendale is working on establishing a 6-month calendar of webinars. We have 3 locked in. The next one is on February 2nd. Let me actually pull that data up real quick. So our next webinar is on procurement and free business certification opportunities, and that is a webinar hosted or co-hosted by City of LA's procurement chief procurement officer. That's taking place February 2nd at 10 a.m. And then after which we have another webinar on February 9th. So our webinars are basically taking place on Thursdays. So February 9th at 10 a.m. we'll be covering tax preparation for small businesses. And then February 16th, we're finalizing a webinar on access to capital. So if you'd like, please go ahead and email me and I will be sure to share all of these webinars with you going forward. That's probably the best way until I do put out the calendar. It looks like we have no more questions. Oh, perfect. Annie, thank you for that. So if you check your chat, we do have some upcoming webinars from Pasadena's SBDC. There's a link as well. And I'll go ahead and share my email address in the chat feature. Feel free to email me if you have any questions going forward. With that said, Xiomara or Dawn, would you have any maybe closing remarks?
Yeah, absolutely. I just want to remind everybody too that we do have a few webinars. Thank you, Annie, for putting that link on the chat. We do have a webinar tomorrow on how to hire and onboard employees, and that's at 10 a.m. And every Wednesday we have small business talk, and we interview an entrepreneur or cover a topic that's pertaining to small businesses, and that is every Wednesday at 10 a.m. If you want to follow us on our Instagram channel as well, we do have information every week about our webinars and any pertaining information that comes through for small businesses in the area. So with that, just like to thank you for having me, and I'll pass it down to Dawn to have any closing remarks.
So thank you, Xiomara and Hurik. I also put our website in the chat. We send out a monthly newsletter and it'll keep you updated on our workshops. But again, just want to say thank you for making the time. And we look forward to sharing more information with you in the future.
Perfect. Thank you, everyone. And this recording will be available on our YouTube channel as well as our website. And I'll go ahead and input the website, which is chooseglendaleca.com. If you want to go back and look through it. And then Xiomara, will they have the opportunity to see the slides that you presented today?
You know, we typically don't share the slides just because information is changing all the time. But if they reach out with questions, I'd be happy to answer any of the questions that come up in regards to any of the slides and the materials that we cover today.
Perfect. And then Mindy is asking, are we allowed to share copies of screenshots?
Yeah, that's fine. Yeah, if you took screenshots, that's okay.
Perfect. Okay, so with that said, thank you everyone for joining us today. I hope this was very informative for you. And if you have any questions, feel free to reach out to either one of us. We're happy to help you. And we're looking forward to having you attend our future webinars. Thank you and have a wonderful day, everyone.
Thank you.